happened, like at, because we're going to record this story. Just like everybody, I'm working from home, and I just got an Amazon delivery package like we do most days. And this one was so cute because I didn't know it was coming, which means my husband ordered it. And inside are little shoes for my 2 little kids that he like bought, like, because they need little shoes. But he also bought me 2 pairs of shoes, just little sandals. And it's like, that's pretty sweet. I am so excited. He's buying me little pairs of shoes. So may you have a special someone in your life that goes ahead and just sees the shabby wretchedness that you're wearing on your feet and just takes it upon themselves to buy you new shoes. It's really hilarious. Oh man, so that's true. I guess not everyone is like intimately involved in my affairs. I have 2 little ones, Aurora 4 and Jack Bear 3. Some of you had the pleasure of meeting Aurora and Jack Bear when I used to schlep them to all of my on-site visits when they were little babies. Now they are little toddlers, and they are very active and adventurous and maybe a little bit of monsters. Yeah, they miss your face too. Aurora's gonna start kindergarten in the fall. It's kind of a big deal. But she's like 4 going on like 34. So she's gonna be just fine. But I'm not okay. I'm actually getting ready to go on my first tribal site visit in like a year and a half. I'm really excited, but I'm nervous. It's going to be weird going out in the world. I know, I'm excited. I'm mostly excited, except both of my trips are in the Southwest, and it is hot out there, y'all. It's like above 100 in both places. It's trying to like prep my students. It's like we're going into the north in the winter. We have to like prepare. We need supplies. Oh my gosh. All right, well, we've hit 1:15, and so I would like to honor all of your time and patience and go ahead and get started. As always, but especially because this is the last session of a pretty meaty conference and you all are here attending virtually on Friday, you deserve a round of applause. But I also encourage you to conceive of this session as your own. Feel free to ask questions. I think we should try and make this as interactive and useful and responsive to you as possible. And so I very much welcome that. Otherwise, I'll take the lead and go through these slides. These slides will be generally available on TLPI's website. I've presented this session before, so if you've seen this before, I think a lot of it will be familiar. I just want to give a heads up for that a lot of these collaboration materials are have been presented at prior presentations. For those of you that I don't know, hi, my name is Lauren Van Schilfgaard. I am a former staff member of the Tribal Law and Policy Institute, to which I would like to very much honor and thank for putting on such a beautiful conference. I presently am now, as the slide notes, at the UCLA School of Law, where I direct the Tribal Legal Development Clinic. I supervise law students as we take on projects with tribes and tribal organizations, including code drafting and other types of legal development, including healing to wellness courts, which I love dearly and very much see as the future of not just tribal judiciaries, but of all judiciaries. I think particularly in 2020, but as we've been sort of building towards a long time in identifying the limitations of the adversarial system and how in our pursuit of justice, it's really just not getting us there. It is incredibly expensive, but most importantly, it appears to be actually harming our communities. And so I think healing to wellness courts is just one new perspective on how we can better approach resolution and healing within our communities. However, tribes, despite everything going against them, having built these incredible systems, are still compelled to exist in this jurisdictional maze amongst many other barriers, including limited funding. There is just a lot of Western pressure fighting against the existence of tribal judiciaries. And so I think collaboration is one potential salve for that. But as we, explore and consider and sort of weigh how collaboration might serve our communities and might serve our participants, there's so much balancing that has to be taken place. How is this best going to serve our needs? What capacity do we have to give? And how does this relate to this overarching jurisdictional framework that appears to be operating on this bed of sand? Things are constantly shifting. We're constantly getting new decisions out of the Supreme Court, re-articulating, redefining what that jurisdiction is. I was just reading the recent case that just came out today regarding Chehalis and what is a tribe? We're still litigating what is a tribe. And so it's in that complexity that on the ground, we're trying to navigate not just what the adversarial system should be, but how we should relate to our neighbors. That being said, I think collaboration is really the intersection of the point of what can we do and what should we do, right? If we were to delete all the borders, delete all of the jurisdictional nonsense, and conjure up a system that was actually responsive to our communities and our needs, it would likely look differently. And I think collaboration is ideally, hopefully, the manifestation of some of those aspirations. That if we work together and just assumed that the typical barriers didn't exist, what could we do? I always say, approach this with a grain of salt, because the realities, the practicalities of collaboration are contingent not just on the legal factors, not just on the resource factors, but a lot of it is personality driven, history driven. What are the realities of the relationships between these communities, some of which are very recent, some of which go back, decades, centuries. These are all things we have to contend with and be very realistic when we approach collaboration. That being said, for the rest of this session, it's really an exploration of the huge spectrum of potential collaboration that's out there, sort of as a permission, a blessing to you that there's lots of different ways that this can take. And in this particular instance, baby steps are great. Doing things and asking for permission later are doubly great. There's lots of ways that you can do this, including off the books, that have produced some of the most noteworthy outcomes being identified today. I'll also note, just as a side, collaboration is very buzzy right now. It reads really well on grant applications, and not that that's a reason to do anything. It's actually a terrible reason to do anything. But if you were looking at this anyways, I will say, put your marketing PR hat on. People love reading about collaboration. And so don't undersell yourself. This is totally an area to oversell yourself, because I already know the fact that you're here, the fact that you're advocating for your community, exploring about re-identifying and conceiving of your tribal court means you're already doing amazing work. This is just an instance, a way to package it and get paid for it. Happy to talk about that in another session. Okay, oh yeah, speaking of federal funding, TLPI is graciously the recipient of federal funds, and an instance in which I think the federal funds are actually going to producing great work and great technical assistance. So that's great. It's also worth noting that it helped pay for this session, so heads up. And by the way, speaking of, we should also have sessions on like how to get federal dollars to all of our healing to wellness courts here. What is our goals for today, our objectives? Spark ideas. I want to be creative. I want to be responsive to what you're doing. And so this is really just like, I want, a brain map of like all the different things that we can, of the possibilities out there, and have a discussion about what some of those, can look like. Here is a beautiful picture of at least 2 of Jessica Harjo's kids for whom she gave us beautiful permission to photograph. Why should we even be entertaining this discussion? Well, as I mentioned, tribal jurisdiction is both limited and complex. I have the honor of introducing law students to tribal law. And before I can even do that, before I can even crack open the incredible beauty of the way that different tribes have approached reiterating their traditional laws in the 20th and 21st centuries, we have to slug through the current state of criminal and civil jurisdiction. And it takes like half a semester. And they all stare at me with these blank faces like, this doesn't sound like anything we did in our first year of law school. Like, this doesn't make any sense. And it's like, you're right. You haven't heard about this because it's not discussed anywhere, even though every single federal and state practitioner in the 34 states that have federally recognized tribes have to deal with this. And you're right, it doesn't make any sense. It's totally complicated and doesn't actually produce a great system. But this is the reality. And tribes are on the front lines. Tribes not only have to deal with this, they frequently have to explain it. They have to be the educators about a system that's imposed on top of them. It's bonkers. But it's our cross to bear. And with that comes opportunities to approach our neighbors and talk about like, this system doesn't just harm us, it harms this entire community. And so the way to really get around this is for us to work together, because it's true that tribal people are dual citizens in both the tribe and within the state and federal government, but also our friends and neighbors who might not be members of the tribe are nevertheless also impacted by this jurisdictional maze, as well as their inability for the tribe to meaningfully respond through full territorial jurisdiction. Because tribal people are dual citizens, because we have non-tribal citizens living in tribal lands, it is more often than not that when we are targeting our high-risk, high-need participants, that the tribe is not the only jurisdiction in which they have cases. It's also true that many of our participants have complex justice histories that include both criminal records as well as civil records, including family dependency cases. As a healing to wellness court, one that seeks to bring in many different parties, it's also true that we seek to provide a holistic response that can and should include consolidation of those complex legal consequences that our participants are facing. That means that we can't just have blinders on looking at just the tribal docket. We have to look at what is this participant experiencing. They are experiencing criminal and civil cases, both in the tribe as well as in this county. If we don't talk to the county about how to consolidate and develop a full case management plan that encompasses all of the participants' needs, then we're really only doing half the work in serving this participant. And so our obligations to this participant, to their case management, compels us to look at their full docket that's beyond just our jurisdiction. Money. None of us, even the most well-funded gaming tribe in the country, does not have a sufficiently funded system to have a wellness course that I think we all envision in our mind's eye. coming together is just one way to connect the dollars. And finally, we know that even for participants that may not be within our system from a jurisdictional standpoint, we know that the systems and services that they have access to outside of the tribe may not be sufficient to respond to their needs. We were talking a little bit in the plenary this morning about the intersection with ICWA and family dependency law, and a lot of the quote, active efforts that are provided to help reunify families and dependency system just weren't designed for Native people, or they're just not as effective for Native people. And in fact, even though they might be in the state system, if they, similarly situated families in the tribal system are going to have access to more responsive services because the tribe is more culturally competent in their needs. And so even if our incentive is not less jurisdictional and merely like these are our people in other systems, hey, county, if you partner with us, we might together produce outcomes that we couldn't do separately. So take it. So that's my pitch, why we should even bother to entertain going into the sterile conference room and sharing stale donuts together. Can you imagine? It sounds so nice now. For me, this goes back to, I had the pleasure of doing a paper with a fellow Native attorney, and we were talking about, why we always, hate on the adversarial system, and what are we really trying to get at? Why is this conception of a battle, not really just great for us? And it's really part of the issue is that it isolates the defendant into the solitary individual, and that the system is based on prosecuting this individual. And so we fortify this individual by seeing their individuality as a set of rights that they have in opposition to the government. They have the right to due process, the right to equal protection, the right against search and seizure. And so the whole system is trying to get at the defendant and get past these individual rights. And that's just really not reflective of, I think, how a lot of Indigenous traditional systems perceive their role. It's not in opposition to the defendant, nor do we perceive the defendant as an isolated individual. Rather, this individual is a community member that has significant and complex connections to the rest of the community. That includes their immediate familial relationships, it includes their extended family, it includes their clans, it includes the entire tribe. And it is those connections, rather than these isolated individuals, that are the relevant stake around which we orient the system. Therefore, their rights as members of the tribe are less reflective than their obligations to other members of the community. Similarly, the community has obligations to those members. And so when we have a participant in our community in need of accountability and support via something like a healing to wellness court, our response is rooted in our obligations to them via our connections as a community member. And so these jurisdictional mazes are nonsense, but they also are a barrier to really perceiving the full complexity of those obligations. Just because someone is charged outside in an outside jurisdiction, even though they're just, a hop, skip, and a jump away, our obligations extend to that person because they are not, based on the limited tribal lands as they exist such today. They extend to the people. And so for me, that's how I like to perceive, why do we have, why should we collaborate? Because it is our obligation as a sovereign to do so, to at least explore the feasibility of how we can better reach our community members and fulfill our community obligations. Wellness courts happen to provide a great model for collaboration. Why? Because the whole deal is collaboration. Wellness courts, at least as they extend to the history of drug courts, right, are this explicit rejection of the adversarial system and its isolating tendencies, right? That it's like, rather than allow the prosecutor to absorb their, duties isolated from the defense counselor, isolated from the judge, we're going to break down all those walls and have everyone sit together and cut through all of the procedural nonsense and really talk about what needs to happen here. What does this participant need from us? And what are we going to ask of them? And we're going to have this conversation over and over again until this participant is sufficiently supported. The whole deal is collaboration. I think where the jurisdictional collaboration is really just pushing that model a little bit wider out, that the collaboration has thus far been defined by the jurisdiction of the tribal government. Let's just go one circle wider and bring in other jurisdictional partners to the extent that they are going to benefit the circle, right? That's the driving force remains the same. We bring in partners because they benefit the circle. Their input is beneficial for the entire group, and the group becomes greater than the sum of its parts. That doesn't change just when we leave the jurisdiction. What does mean we have to be very intentional about how we define that relationship, because we don't have this default same assumptions to like the tribal government, but it's not an insurmountable barrier, at least I placed. There's lots of other great reasons why this is beneficial that we've sort of alluded to already, right? We have access as tribal communities to more innovative and culturally relevant services. It's possible that our participants it's more geographically convenient. They actually live in the tribal community. The reverse could be true too, right? We could be exercising jurisdiction over a person who actually lives outside of the community and could benefit from services over there, whereas coming to us is a really arduous commute. Together we have more, together is more, more is more. We are able to offer more supervision, including if someone lives and works in different jurisdictions, having multiple points of supervision is beneficial. The multiple case plans. I really think this is like where we need to focus on. If we're not coordinating case plans, that's like the bare minimum that we can and should be doing. Ideally, we're coordinating like full-blown like case dockets, consolidating sentences, consolidating legal consequences. That seems to be tricky for a lot of courts, but I mean, hopefully we'll get there. Yeah. These are all getting at what I sort of got at. I'll let the rest of the bullets stay there. Kinds of collaboration. This arrow suggests a linear, like hierarchical progression. I do not mean to do that, only to say that there are different varieties of progressions, some of which feel more formal than others, but their formality is not reflective of their what's the word I want, about the effective collaboration that they can produce. Okay, so we're going to go through some of these, ranging from the informal, AKA like oral person-to-person agreement, to formal, like full-blown codified agreements. Some of the advantages and disadvantages. I used this word plasticity earlier today, but it is true that when you have, someone talking on the phone and agreeing to like meet in a parking lot and share notes, that is really flexible. There is a lot that you can do just by calling someone on the phone, including your organizational counterpart, and just being like, here's the deal. Like, what do you think? Wouldn't it just be easy if we just like talk to each other about this? Like, they don't even need to know that we're doing this. Like, we're just going to do it. Let's just do it. Okay, let's just do it. There's so many possibilities, and all it requires is just like right? 10 minutes of our time to send that quick email, give a quick heads up. This can happen in real time. It's incredible. The disadvantages, right? These types of relationships are just that. They tend to be based on, purely personal relationships. And so they come and go with those personal relationships. As soon as a position turns over, that collaboration turns over. If you don't have something formalized, then there are no expectations for why the rest of the team should be fulfilling those obligations. Those were purely personal obligations. They also are ripe for unfairness. It seems like there's a perception that someone's getting special treatment purely because of the existence of this personal relationship, which, depending on what's currently happening in the wellness court, as well as just the nature of wellness court and how things change week to week, and how drama just seems to spark out of nowhere, the fear of this misperception, I think, is really very real and needs to be handled cautiously. Oh, nice. We got some Sitka stuff going on. That's cool. Formal agreements. This is, taking some of those disadvantages from our informal and being like, all right. Let's just write it out. Let's just write it out and make this real. Let's have a ceremony. Let's do this. It provides clarity and stability, much like we were talking about in how codifying creates clarity and stability. These can be a good thing. They survive the originators of the collaboration and provide expectations that collaboration shall go forward and is now a core component of these systems. They help alleviate perceptions of fairness because hopefully similarly situated participants are going to get access to the same types of benefits that the collaborations produce. So it's not dependent on, being in the right place at the right time. And I think they're more efficient in leveraging resources because more people are going to be able to know about the collaboration and chime in when they have a good idea. The disadvantages. It is not a coincidence that we don't see that many examples of formal collaboration out there. They're really hard to implement. There is no bones about it that the idea of interjurisdictional collaboration, even outside of the tribal context, aren't just very frequent. We are so ingrained in these jurisdictional boundaries, really defining our systems and the relationships that we have with each other. Collaboration is inherently out of the gate out of ordinary. It's not typical. I'm just dipping my toe a little bit into international law. And the truth is there really is no international law. It's just like these loose agreements because we have a very limited sense that beyond the nation state border, it's a free for all. And in a lot of ways, there's a similar approach beyond the tribal border. And I'm really sympathetic to that because the boundaries of tribal jurisdiction are under such frequent and hostile attack that our defenses are up for a reason. Meanwhile, the perception of tribal governments is so volatile, and there's such ignorant and naive perceptions about what tribes are and what their authority is. As I mentioned, the Supreme Court just litigated what is a tribe. There's so much ignorance that having to overcome that and ensure that the tribal government remains protected and the sovereignty remains intact often forecloses on meaningful collaboration, and certainly the formal agreements. Other barriers, funding seems to always blow it up. As soon as someone proposes, who's going to pay for this, or let's go into a grant, but who's going to manage the money? All of the great intentions really seem to take a backseat. And I've seen numerous projects, very promising projects, stumble over the funding question, which is a bummer. Liability concerns, I concede when lawyers get involved, they frequently doomsday projects to death. Just thinking about all of the worst case scenarios, and that frequently blows it up, which is lame. Thanks, attorneys, thanks. And then when these do happen, it frequently sends just a bad taste in everyone's mouth, and it sort of needs a new generation of, of turnover for people to be like, it would be a great idea if we talk to each other. And so I, challenge this group to really push the envelope to overcome what so many have not been able to overcome, but acknowledge that it's tough out there. It is tough. Jurisdictional boundaries are just like these fortified walls that for some reason have just proved impenetrable for so long. Some considerations, if we nevertheless are going to try and go about this, what are some things that we should be ready in our little briefcase to discuss? So when I think about a typical wellness court collaboration, I envision a participant who has a case. They were picked up, say, for possession by one jurisdiction, and the tribe and the county, say, want to negotiate and share some type of jurisdiction over this participant in order to leverage resources. But it's not clear how this is going to shake out. So the first is who really retains, quote, like legal jurisdiction over that participant, and what does that, the extent of like the share or the transfer of jurisdiction look like? So every drug court and every wellness court has a different approach to the, assuming it's a criminal charge, the pre and the post adjudication. And for a lot of courts, I think we quickly forget why we decided to go for one or the other. But as soon as it's codified, it's stone, it's non-negotiable. There's equal protection reasons for why we wouldn't want to negotiate there, but the county treats it as a post adjudication. There has to be a guilty plea, there has to be a trial, and until there is, we can't even begin a conversation about, interjurisdictional collaboration. While the tribe is like, look, we are not interested in like racking up criminal crime, charges on our tribal members. And in the meantime, they're just languishing in jail when we could be serving them in healing to wellness court. Let's go. These are like battles that we sort of need to either, negotiate up front before there's a participant we're fighting over, or be willing to just play it as we go. But this is like a very typical battle, right? Once that transfer happens, there have been instances where, say a county has jurisdiction over a participant. Sure, tribe, you want to have them in your healing to wellness court as like a condition of probation for us? Sounds great. I love it. But if you ever want to issue a sanction or incentive, we're going to see that as like a court involved moment, and you're going to need our permission to do that. Like, okay, so like we need to like file a motion with the court every time we want to give an incentive. We need to file a motion with the county court every time we need to sanction them because they didn't show up for a drug test. Oh, that just sounds like a lot of paperwork. It doesn't sound very efficient. It doesn't sound very collaborative. Is there any way we can like get past that? Or could you just trust us that when they are in like our full tribal jurisdiction, it is a formal transfer? Is there a way that you can have county, someone from your staff attend our staffing and just be a participant in our healing to wellness court, which effectively provides that county participation and alleviates any legal concerns you might have about us issuing an incentive and a sanction? Similarly, what if they have an attorney? If they have a public defender in the county, will they be attending our court staffings? Will we allow their attendance? Will we provide a defense attorney on behalf of the healing to wellness court? And will those attorneys coordinate and share notes? Will we compel them to do that? All fun issues, not insurmountable, but like fun things that potentially could come up. Referrals. I think this is like sort of a latter question. Usually collaborations are driven like as a participant becomes known to us, but moving forward, how are people going to be taking advantage of our collaboration? Sometimes counties are down to have tribes offer healing to wellness court as a condition of probation, but then they also impose all of the other conditions of probation. Like I've seen, oh yeah, sure, healing to wellness court as a condition of probation. Oh yeah, and they'll also need to get drug tested twice. It's like, okay, well, funny enough, they're actually getting drug tested twice in healing to wellness court. So is that good enough? And it's like, no, no, no. They need to come to the county, come to our courthouse and submit 2 drug tests in addition to whatever they're doing in Healing to Wellness Court. It's like, well, that's dumb. Like, that's just burdensome. It's just like a pain in their butt. Like, maybe if you're going to require that, could we use those drug tests to satisfy our requirements? But also, could we like change it up a bit, because we know that they also need to be drug tested on like nights and weekends when people are more likely to use. Are you going to be able to accommodate that? Is there a way that we could just share the results of our drug tests with you to satisfy your requirement? Is there any way you could just get rid of that requirement, acknowledging that that's already a requirement in our Healing to Wellness Court? That, like, the collaboration, frequently it's the, you know, the devil's in the details, right? Discharge. If the participant is going to graduate or be terminated, who has the authority to determine that? What level of due process protections need to be offered in the hearing to satisfy that for the county? Can they just sign off on like a full faith and credit recognition of that tribal court order? Does there need to be a separate court order from the county? Can we have a consolidation of that court orders? Is it just a recommendation from the tribe where they have a court hearing in the county to sort of adjudicate whether or not the tribe had a fair determination here? What's the decision-making gonna look like here? Also, what are the legal consequences? If a participant is being transferred from the county, do they have access to comparable legal benefits for graduation as our tribal Healing to Wellness Court participants that have tribal cases? Is it going to be obvious that they're different? Is that going to pose a problem in our Healing to Wellness Court because the incentives are so different? Finally, how are we talking to each other? I think some of the best collaborations I've seen is when there's like a human body from another jurisdiction that is in the room, both sides, right? If the participant's in a tribal Healing to Wellness Court, there's usually a county probation officer. But similarly, if a participant is in a county court, there is a tribal team member that is attending those meetings and updating the tribe on what's going on there. But even if there's not a human body, which I recognize that, you know, is a luxury that very few of us have, do we have protocols for how we are going to regularly be updating each other? Is there an expectation for regular updates? Is email sufficient? Have we consolidated cases at all? Is it going to be in like a formal court record that is satisfactory for our own court record obligations on both of our sides? How are we going to accommodate that? And is that just going to be something we're going to dump on the wellness court coordinator to figure out? We should be thinking about how all of those nitty-gritty details are going to work out. So this is sort of just another way to conceive of these levels of interaction, right? Of like, I don't know, some researcher who's like, minimal cooperation, co-creation. But I think that this has really manifested for a wellness court and just a way to sort of like conceive of like, here's what I'm thinking. And so this is purely a way to categorize this in our mind. There's no other like thing that this impacts, certainly nothing like due process or funding. Like, this is just a organizational tool. Minimal corporation. So now I'm going to go through some specific examples that I personally have encountered. This is not necessarily reflective of what's out there. I see the chat is relatively active of like other examples of stuff. So I encourage you to share and or like, you know, chime in for other stuff that this brings up for you. So, you know, the typical example I talked about is the actual case coordination of a participant. There are so many other ways where our courts can collaborate and benefit from each other that doesn't necessarily include a specific participant and their case. I have seen different courts like physically drive to their neighbor's court and just watch and see how things are going on. There's something really empowering about knowing what your participants are experiencing when they are being processed in another jurisdiction. Do you know what the hallways look like? Do you know what the bathrooms are? Do you know what the waiting periods are? Do you know if there's a safe space in case somebody has a domestic abuser that they might have to be in the courtroom with? Do you know if the judge is sitting really high up or if they're on the same level? What does the process look like? Can you coach your participant for what they might expect when they're in this different system? The Pueblo of Laguna for a long time was I forget what they called it, but it was like a model healing to wellness court where other tribes were invited to come and observe their court proceedings as like a take notes. This is a good way to do it. I believe another tribe is currently serving in that role right now on behalf of the NADCP, but there are lots of tribes that have an open door policy, and particularly for tribes that are new to healing to wellness court and not exactly sure what this looks like or how they want to do it. Go watch Courts in Action. There is nothing more efficient than just watching a healing to wellness court hearing to get a take for like, yes, these are things I liked. These are things I didn't like. People sat in the gallery. I liked when tribes sat in a circle. The judge was up here. I liked when the judge was down. This judge kept their robe on, which I kind of liked. This judge didn't, but I still kind of liked it. There's like so much that we can learn from each other by just visiting. And the same is true for our county partners as well, that we might still operate as separate jurisdictions, but we can nevertheless advance both systems by working with each other, including on the procedure side rather than just on the participant side. Especially a couple years ago when the opioid crisis was raging, though it still is in many communities, and in many other communities, meth is raging, and we're still sort of figuring out what the ramifications are of the pandemic. A couple of tribes, including the Paiute of Utah and Forest County Potawatomi, held just like regional naloxone trainings, which was cool because it benefited their own community. But it was also like a secret ploy for like, let's meet our neighbors, right? Like, let's have like a pancake breakfast and just like share notes. So it was a resource that they were offering to like first responders, but for the entire community, county, municipality, villages, everyone, like, let's come together. And it proved to be very unifying. It really seemed like, the tribe is like, they're willing to give, and they're not, and like in this like small thing, which was the thing they were doing anyways, there wasn't like this quid pro quo expectation that served to be really beneficial and actually was useful for the tribe in being like a good neighbor, and then getting phone calls after that for other collaboration inquiries, which was super interesting. And then this Northern Michigan wellness court training, this was something we participated in TLPI, where the tribe had reached out to us of just like, hey, we just want to do a wellness court training. And I was like, cool, like, yeah, we'll come up. They're like, is it okay if we invite like some of our other partners that are non-tribal? It's like, yeah, like more the merrier. It turned into this whole thing where it was like this like regional, state, city, tribes from like all over the region. And suddenly people were sharing notes, and I saw business cards flying over, and there was a couple people from the AG's office, and it's like, okay, this is turning into a thing. Like, that's cool. Super, super interesting. Full collaboration. The Yurok tribe is such a great example. They have been like massaging their two counties so intensely and have produced such incredible results. But they're also an example of like context matters, same tribe, and they exist within two different counties. And because the context within those counties is just different, they have produced different MOUs with those two counties, depending on like what was needed. And so you can see with Humboldt County, they developed this MOU where they have the option for transferring. And I think that option is both for like the participant, if they would like to come to healing to wellness court for a state charge that they have. They also provide joint supervision so that the Yurok tribe has this healing to wellness court case. They're leading probationary supervision, but Humboldt County also has probation officers that are also conducting supervision. Pretty cool. Meanwhile, in Del Norte County, they pronounce it Del Norte, which I always thought was weird, but that's how they pronounce it. They have more of a like shared model of this concurrent jurisdiction over juvenile cases, and then a different model for adult cases. So it gets kind of complicated, but it's also kind of cool. They're just sort of like making it up as they go and doing what's worked and sort of like moving forward. And it's so fascinating to me that the tribe is just like, look, like this is the pace that each of these counties are moving at. So we're just gonna do it all. We're gonna do both and like roll with it. So regardless of where their tribal members are, they have access to the tribe, which is cool. I dig it. It's super cool. This is from their salmon festival, which is apparently amazing, and I hope to go one day. The Pueblo of Pewaukee is doing more straightforward, healing to wellness work, but they're in an interesting position where they are in this corridor just north of Santa Fe, and they have a number of different tribes that are neighbors that do not have the level of court services that the Pueblo of Pewaukee does. However, for those of you that exist within communities where there is lots of travel between tribes, then you know that your tribal members tend to be all over the place and have charges all over the place. And so the Pueblo of Pewaukee has coordinated with some of their neighboring pueblos that regardless of what, where a person is a member of, and regardless of where their originating charge is, the Pueblo of Pewaukee sort of opens their doors and offers these court services on behalf of that pueblo. So it's sort of like this intertribal healing to wellness court. Pewaukee is here. Of course you're here. Pewaukee's always doing like such amazing things, like nudge, nudge. I totally want to work with you guys one day. They also have this really interesting model where they took a totally difficult federal grant and turned it into sober housing dollars, where they literally just like pay rent on the 2 apartments that are nearest to the courthouse and have turned that into sober living for their participants should they need that, which has developed this intertribal court with sober housing that's right there. And so the supervision is literally on site. It's a really interesting model. And what's also really curious is that Pewaukee has developed a lot of these through the informal process. They have formalized, caramelized over time. But it really started with like phone calls and just responding to the complex needs in real time, producing this seemingly innovative system that is actually just like responding to what the needs were at the time. They also have formal collaborations with the County of Santa Fe. So they are very much, piercing that interjurisdictional collaboration. But I find the intertribal stuff fascinating. And yes, so Judge McGinnis, who is an attorney, fears the crushing attorney agreements. I mean, I think it's so true. Once the attorney get their hands on this, it really seems like nothing happens after that. And so it seems like attorneys are really good at killing collaboration. I don't know why that's the case, but it definitely seems to be the case. So nevertheless, to like give permission for the formal attorney agreement should anyone be interested, there is this sample memorandum of understanding. Mine is hyperlinked. Are you able to click on it and open that hyperlink? No, bummer. Okay, I think it'll be provided. Here, let me do it real quick. Okay, hold on. Copy link. There. Cool. Okay, so this is a sample MOU, purely a sample, hardly a model, but it was pulled together with some state Supreme Court justices. So it has like their blessing, which is kind of nice as a negotiating tool with counties to say that like, this isn't crazy. Other people have endorsed this. Other people have signed on to this. Like we can do something in between, but just goes to show, I think there's a lot of fear around potentially like exposing your jurisdiction to liability. And so I think a document like this is a great way to say like, don't be scared. Like this, a lot of this has already been hashed out. People have already drafted language and like signed their name on it. We can do this. And so I offer this as a tool. Okay, some other examples of full-blown collaboration. The Chickasaw Nation in Oklahoma has like this badass public health system and has been offering this like comprehensive holistic treatment services. And because their system is so robust, they basically were able to approach their neighboring counties and be like, you want in? Like, you want to join the bandwagon and enjoy all of these incredible things? And with that, allow us access to our tribal members that are otherwise in the state system for which our tribe doesn't have jurisdiction because it's off of tribal lands. This was a type of service that was actually referenced in the McGirt litigation as evidence that, you know, the jurisdictional complexities in Oklahoma are bonkers. But out of that, tribes have been able to showcase their incredible capacity that has involved serving not just tribal members, but the entire region. And with that, like, don't be scared about recognizing that, in fact, these jurisdictional reservation boundaries remain intact because tribes have been acting like that since they were removed here in the 19th century. It was super fascinating. And so just from the wellness court perspective, I was able to anecdotally be like, yep, see Chickasaw, they are doing this and doing a really incredible job. I think we also saw evidence of this, you know, during some of the vaccine rollouts, where in Oklahoma, you had a lot of tribes spearheading the effort because they were the ones that had the infrastructure in place. Like, we already know how to do this. We already know how to take care of our community. Here's how it goes down. It's very much in the same line as healing to wellness courts of like, I can't anticipate what the need is going to be tomorrow, but I can anticipate there will be a need, and we're going to need to be able to collectively and holistically respond. St. Regis, how are we doing on time? Okay, got a few minutes. I'll go through these. They, like Chickasaw, have sort of like been like, you know, if you want it done right, you're going to have to do it yourself. We have this inpatient treatment house on reservation that they have signed an MOU with and sort of have this like negotiated, we're going to be sending our people here. We're not shipping them off. Though they also take tribal members from all over, recognizing that a lot of tribal members benefit from a native specific inpatient treatment house. And so it's sort of become this like regional collaboration where I think a lot of tribes really benefit from the fact that not only is it native centric, it's tribal centric, located on these tribal lands, with the St. Regis Mohawk providing this like ancillary supervision. Co-creation. This is sort of like the final frontier for collaboration. But I, again, you know, challenge us to resist the temptation to see collaboration as this hierarchical spectrum. This is an incredible model, but it just happens to work under these particular circumstances. It's not necessarily like the aspiration for all communities. However, it is cool, and it is certainly a challenge to the general idea of these, you know, impenetrable jurisdictional boundaries. Here we have Leech Lake, which I don't think is a coincidence, exists in a PL 280 jurisdiction, a state that exercises jurisdiction instead of the federal government. They formed a handshake, what later developed into a joint powers agreement with the first Cass County and then Itasca County. So much like UROC, have two different counties and develop two different agreements to accommodate the different circumstances based on those counties. They have like St. Regis, this very native-centric treatment approach that they coordinate with counties, sometimes via the joint jurisdiction court and sometimes separately, sort of again responding to the needs of participants and their unique context at the time. I wanted to certainly include this slide to show what like collaboration can mean. Like when we blend a family, there's lots of different ways that you can look like. And so this is just an example of how they blended this family. The judges, they have two judges, occupy the bench simultaneously, issue simultaneous court orders. The idea being between the two of us, we have jurisdiction over you. So we don't need to litigate whether you're Indian or non-Indian, whether we have Montana 2 jurisdiction over you, somebody has jurisdiction. They have a county attorney. They have a public defender from the Regional Native Public Defense Corps, which is interesting because it sort of bridges that like tribal and county perspective. They have probation supervision provided by the Minnesota and the county. They have law enforcement from the county sheriff and the tribe. Their treatment provider is tribal, and then their coordinator is from the county. So it's like kind of all over the map. It's really interesting. And I think you could like flip a coin and like jumble it up and still get a responsive joint jurisdiction healing to wellness court. There's no, at least as far as we can tell right now, like critical core ingredients, except for the judges. And just like a regular healing to wellness court, our judge is like the center stone, that the keystone. We can't have it without the judge. Shingle Springs is another really interesting example. They're situated really comparably to Leech Lake. However, one thing that I really like about Shingle Springs that they did a little differently was redefine their target population. They target technically juveniles, but really define it as a family healing to wellness court. And I think really walk the talk when we talk about like coordinated case plans and addressing the whole needs of this family. And so if there is a family that comes under the jurisdiction of the tribe, it's really that whole unit that the case plan is developed around, which I think is really interesting and robust. Otherwise, like Leech Lake and Itasca and Cass County, they have 2 judges issuing simultaneous court orders and coordinated case plans. And then Alaska, one like unifying feature with all of these joint jurisdiction courts, I'll just note, Leech Lake, Shingle Springs, the Kenietze, all PL 280 jurisdictions. I don't think it's necessary, but I do think it's emblematic that PL 280's insertion of a greater state role coupled with PL 280's historical suppression of tribal court development, I think makes for like a ripe, a fertile ground for the development of these joint jurisdiction courts. I'll be excited to see instances outside of a PL 280 jury like context, but so far that's where they appear to be cropping up. With that, I am going to end here and note that many of the things that we have discussed are captured in this recently published publication, which means you have all of the notes as well as this PowerPoint. And so if any of this was intriguing and or confusing, I encourage you to pull up this publication. Like all of TLPI's publications, it is free and available to you. I also think they are willing to print it out and ship to you, and as many copies as your tribal court needs. And so please feel free to reach out to TLPI and take advantage of that resource. I'm certainly willing to hang out and answer any questions that you might have, but otherwise I would just like to say profusely thank you for all of your time and dedication to attending a virtual conference on a Friday afternoon, no less, and really applaud all of the efforts for you and your court.
Thank you so much, Lauren. And yeah, I'll just kind of track the comments and the Q&A to see if anything comes through. There was a good amount of conversation in the comment box regarding examples of collaborations that are out there. Oh, there's a request for your email, Lauren.
Let's see. I just put your email. I'll put mine in the chat.
Okay. And this is probably like the 15th time each of you had heard this, but we did drop the evaluation link into the comment box as well. Please do complete the evaluation if you can. We always use that information to improve our future workshops and events. And I'm also about to drop good number of hyperlinks into the comment section as well. TLPI we're planning to host a veterans event in the future. It remains to be seen if that will be in person or virtual, but please do sign up for our email list and we can keep you updated on those types of events. I dropped another link in the comments as well regarding our 5-workshop tribal state collaboration webinar series, where I believe you'll all be lucky enough to converse with Lauren again for at least one of those webinars. I'll be dropping a link for our publication resources, should any of you be interested in some of the topics that have been brought up today. And our team will additionally be facilitating a tribal track at the NADCP RISE 2021 conference. Right now, we're in a bit of a limbo situation in terms of technical assistance travel, which is federally funded, though we do plan to be in person and plan an awesome event should any of the grant-funded tribes out there or tribes that do have some funding to send your team members to join us and have a bit of a conversation. So, Lauren, thank you. As always, I couldn't think of a better way to open our final day and close our final day. You are our ringer, and is just an amazing, you had 2 really amazing workshops today, and I learned something new every time.
Thank you. It's really such an honor to be here, and really hats off to TLPI for putting together such a comprehensive virtual conference. They are not my favorite type of conference, but if we have to do it, this was pretty cool. So really, congratulations.
Thank you, Lauren. We'll just keep it open a few more minutes to see if any questions may come through.